This video is an introduction to CCPA. I'm going to cover an overview of CCPA in this session. Let's take a quick look at the topics that we're going to cover. Overview to CCPA. What are the rights of a California consumer? What are the businesses that are going to get impacted by CCPA, their obligations, and most importantly, what is a definition of a business? What are the penalties that a business is looking at in case of violating the CCPA guidelines? And a quick glimpse at a private right of action, penalty on violating it, what are the common concerns or the key takeaways from it. Welcome to Tech Talk. My name is Tanya Khanna. I am a BTech graduate from UPTU University. I'm also an MBA graduate from Symbiosis. I'm a certified data privacy consultant and I've got another list of certifications to my portfolio, but let's not get into it. I hope this video adds value and gives you what you're looking for. In case you want to know something else, please feel free to comment on the below and let me know so that I'll get back to you with whatever you want to know at. Please don't forget to hit the bell icon, the subscribe button, and in case you like the video. So, okay, so to start with, CCPA is California Consumer Privacy Act. It got into effect on 1st of January 2020. That means its rules apply to a business organization and it gives the rights to the California consumers from January 1st, 2020. On June 28, 2018, the state of California passed this act called as CCPA. Who has customers, any business who has customers or employees located in California, this act impacts those businesses. So basically what I'm trying to say is this act impacts any business who has customers or employees located in California, irrespective of their location of the business. It has expanded this law CCPA this act CCPA Act has expanded the rights of consumers and on the other hand requires the businesses to be more transparent on their personal information and the ways and methods they use to collect it and the use it and disclosure of that information. The businesses that are in scope now need to extend their data management practices and update their privacy policies as well to bring in line with this act. Now, what is CCPA? CCPA is California Consumer Privacy Act. The CCPA has restructured the privacy and cybersecurity laws for the residents of California. It has given the residents of California privacy rights, basically five major rights, and it has empowered them to protect their personal data. Let us take a look at these five rights. Now, number one, the right for consumer to know what personal data. Over here, it's very important to see what personal data is being collected and how it's being used. The right to know whether it's being sold or disclosed. If it's not being sold or disclosed, then it's really not harmful to anybody. The right to data portability, the right to opt out of the sale of personal information to third parties, and lastly, the right to request that a business delete personal information that has been collected. Okay, so these are the five rights that CCPA empowers a California residents with. Rights of a California consumer. What are the rights that are there for a California consumer? A right to know what personal data is collected, age, height, gender, sex, whatever is being collected, they have a right to know. Used, shared, or sold by the businesses. a right that that personal information that was deleted, that was collected to be deleted. Okay. So if a personal data has been collected, the California consumer has a right to ask for it to be deleted, a right to prohibit the sale of this personal data. The law has explicitly, protected children under the age of 16 by it says that children under the age of 16 must give an explicit consent. Over here, they have to give an explicit consent to have their data eligible for sale, and a parent or a guardian must give explicit consent for a child under the age of 13. A guarantee that consumers who exercise their right under CCPA will not be penalized with higher prices or lower levels of services than those who do not. See, this is where the discrepancies come in, or unfair treatment is given to people who raise their voices in some parts of the world. So this is to protect those people who are raising their voice against the protection of their personal data, which is very, very nice move, I think. What are the businesses that are subject to its impact? To discuss this, firstly, we should know what is a business. Business is any entity that collects personal data or personal information about California residents and makes decision about how and why the personal information is processed. If a business either, so basically, first we need to define what is a business. A business is any entity that collects personal information about the California residents, okay, and make a decision about how the personal data is being processed. Is the business that is subject to this CCPA Act. Now, there are other parameters also to this business. Firstly, if a business has an annual gross revenue over $25 million. Secondly, if the business either annually buys, sells, shares, or receives personal information of over 50,000 consumers, or the business drives 50% or more of the annual revenue from selling personal information. So, if either of these three conditions are met, the business is subject to get impacted by CCPA. What are the obligations for such businesses? The first obligation is notify a customer in advance of the personal data that is being collected. A customer should in all times know that their data is being collected. Second is they have to make it easy for a consumer to exercise their right under the act. How can you do that? You would be wondering, how should I do that if I'm a business? How should I enable this? So you should do that by providing links on your website or maybe your mobile phone apps to prohibited selling their data, and a consumer should be able to access those links and exercise their rights where they do not agree that their data should be sold to a third party or any other use. So those links should be made easy. That's how you make it easy for the consumers. Third is by responding within a specific time frame to requests made by consumers under the act. Fourth is verifying the identity of consumers making requests under this act. The next one is disclosing any financial incentives offered in exchange for retention or sale of personal data, as well as how the value of this data was calculated. Also, businesses must explain why they believe that such incentives to be permitted under the CCPA. The next obligation is that business must keep records of all such requests made under the Act and how the businesses have responded to such requests. Maintaining data inventories and mapping data flows, inflows and outflows, disclosing data privacy policies and practices of a particular business. What happens if they do not follow such obligations, then there will be a penalty on violation of CCPA. So if a business does not comply to the norms as stated under CCPA, they are subject to civil action. They are subject to civil action by California Attorney General Office. Penalties as per international, sorry. So there are two kinds of penalties. First is penalty as per the intentional violation, which can go up to $7,500. And the second is penalty as per unintentional violation, which is, you know, up to $2,500. Now, what is private right of action? So, firstly, private right of action provides for statutory damages. Now, you must be thinking, I mean, okay, but what does that mean? So, in many data breaches, demonstrating a quantifying damage caused by a breach can be very, very difficult for a single person and making it hard for the plaintiff to successfully sue and obtain monetary damages. In this scenario, statutory damages eliminates that particular hurdle of quantifying the damage by dispensing with the need to prove actual damages. A plaintiff's attorney may be more likely to bring this this class action lawsuit on behalf of groups of data breaches, plaintiffs with this new tool in hand that the CCPA Act has given them. The CCPA provides courts with a laundry list of considerations for determining the amount of statutory damages to award a plaintiff. The list is very comprehensive. It includes I think five or six major, bullets, such as the nature and seriousness of the misconduct, the number of violations, the persistence of misconduct, like even after it has been brought to the notice of a business, the persistence of misconduct, till what extent it's been happening and going on, the length of the time over which misconduct has occurred, the willfulness of the defendant's misconduct, and the defendant's assets, liabilities, and net worth. So, all these points will provide a ballpark figure to the, what do you say, this thing to provide a such, amount to be decided of statutory damages to be awarded. Okay. The second is new provision of the CCPA allows businesses the opportunity to avoid a consumer suit. Now, this is very interesting. Okay, this particular provision also helps the businesses to avoid. It gives an opportunity. Don't forget the word. It gives an opportunity to avoid a consumer suit under the private right of action provision by curing the violation of its duty to implement and maintain reasonable security procedures and practices that resulted in unauthorized access and exfiltration, theft, or disclosure of the consumer's personal information. Now, to pursue statutory damages under the CCPA, the would-be plaintiff must first provide the would-be defendant business with 30-day written notice that the data security provision of the CCPA has been violated. The business then has 30 days to cure the violation and provide the plaintiffs with an express written statement that the violations have been cured and that no further violation shall occur. If the business does so, then the plaintiff may not request statutory damages in a subsequent suit. The statute does not define cure, so it remains to be determined how a business can successfully cure data security violations under the this thing act. The concept of cure will require clarifications from California General Attorney General only when he issues regulations, or will be litigated after the laws goes into the effect. So when I say the law goes into the effect, I mean the law has already started from January 1st, but the enforcement has not yet begun. Okay, we'll cover this in the next slide. You'll get to know why. Third, the CCPA authorizes a private right of action only for breaches involving non-redacted and unencrypted personal information of California consumers. So, what do you mean by non-redacted and unencrypted personal information of California consumers? The private right of action provision selects a narrow definition of personal information than what is used throughout the rest of CCPA. Okay, deferring instead to one subpart of the definition of personal information found in California data breaches. Thus, a consumer can bring suit under the CCPA only if the following information is accessed or obtained without authorization. Now, what's that information? An individual's name along with his or her security, social security, or driver's license, California identification card number. So first is security, social security, driver's license, California identification card number. The second thing is account, credit card. So all these things alone do not matter. They have to be clubbed with his or her name. Okay, that's how a PI works. That an individual name along with social security, driver's license, or California identification card number, individual's name along with account, credit card, debit card number in combination with a code or a password that would permit access to financial accounts. And thirdly, an individual's name along with his or her medical or health insurance information. Thus, if any of these things combined together are there, then it authorizes it's said as a breach. Thus, a consumer can bring a suit under the CCPA only if the following information is accessed or obtained without authorization. Okay, coming to our next line. Some limiting provisions in the CCPA that are worth highlighting. First, the 30-day written notice and cure provision, like we discussed in the one or two slides above. Under this CCPA provision, before any individual or any class action for statutory damages can proceed, a consumer must provide a written notice identifying the specific provision of the law that the consumer alleges were violated. If the violation can be cured and is cured within 30 days, okay, this 30 day is very important, within 30 days, and the business provides the consumer an express written statement that a violation have been cured and that no further violation shall occur. So the thing is no further violation, right? No further violation shall occur. Okay, that is very important. Then no further, so no action for statutory damages or class-wide statutory damages may be initiated by the consumer. For any continuing CCPA violation in breach of the express written statement, a consumer may enforce the written statement and may pursue statutory damages for each breach of the express written statement, along with any other CCPA violation after the written statement. This 30-day written notice provides companies a chance to check their claims, avoid potential litigation for statutory damages. Now, the notice and the cure provisions apply only to statutory damages. There is no comparable requirement if actual damages are being sought. Okay, this is not for actual damages, this is only for statutory damages. Okay. Second, the private right of action applies to uh, one non-encrypted and non-retracted personal information. So the private right of action applies to non-encrypted and non-retracted personal information. Companies can protect themselves, by encrypting or retracting a personal information that industry standards and best practices are used for encryption and retraction. So that's how the company can protect themselves also. Okay, this is for company. My pen is not working. So basically, what I'm trying to say, this is there that non-encrypted and non-retracted personal information. This is to give a company to protect themselves also. So if a company uses this thing, they can protect themselves. So the scope of personal information for the private right of action is limited to specific data elements noted above. The limited private right of action does not apply to broader definition of personal information, used throughout the CCPA, which includes, for example, commercial information, biometric information, geological data, internet, or the other electronic network activity, audio, electronic, visual, thermal, or similar, information, among many other types of information that identifies, relates to, or describes reference incapable of being associated with or could reasonably be linked directly or indirectly with a particular consumer or a household. Okay. Fourth, the violation and private right of action are only triggered when a company violates the duty to implement and maintain reasonable security procedures and practices. Now, as a result, California's reasonable cybersecurity statute provides a line of defense. Now, what's that line of defense? While reasonable security procedures are not defined and are factual based on the circumstances, the law particularly states that a business that owns licenses and maintains personal information about a California resident shall implement and maintain reasonable security procedures and practices appropriate to the nature of information to protect the personal information from unauthorized access, destruction, use, modification, or disclosure. Thus, if a company can establish that it has maintained reasonable security procedure and practices, it can use that as a defense, to CCPA private right of action claims. Finally, the CCPA expressly provides that the private right of action only applies to the security violations defined in Civil Code section 1798 150A, and that nothing in this title shall be interpreted to serve as the basis for a private right of action under any other law. Okay, so that is very, very important as a line. Okay, coming to penalties on violation of CCPA, private right of action. Now, this right comes into play where the personal information is subject to unauthorized access, theft, or disclosure. Under this, a business could face paying between $100 to $750 per resident or incident. Now, the thing to see over here is regardless of whether the actual damages are shown or not. Okay, fine, sanction, and loss of goodwill is enough. Implementation and concerns. So, the CCPA took effect on 1st of January 2020. Enforcement, including the imposition of fines, will be delayed till June, like I told you earlier. Okay, so imposition of fines and everything, they will not start until June. Now, internet-based businesses, many of which are based in California, have been among the most vocal opponents of this law, arguing instead for a US federal legislation that would set uniform standards across the nation. Part of their concern is that each violation of CCPA potentially could trigger thousands of dollars in fines. which can add up to massive amounts across perhaps millions of users in California alone. However, the internet giants like Facebook and Google parent Alphabet, and they are already in compliance with the EU's GDPR, which has much stronger protection than the CCPA, notably requiring opt-in. Now, what is this opt-in? I'm going to tell you in my next video because I don't want the video to be too long also. So, opt-in for sharing personal data rather than merely facilitating opt-outs, as does the new California law. As a result, some observers believe that CCPA will be more burdensome for some small players in the industry, and thus entrench the leaders in online advertisement or advertising. Okay. Now, what are the key takeaways that we have taken by CCPA? The first is California Consumer Privacy Act took effect on January 1st, 2020, but the enforcement, including the imposition of fines, will be delayed till June. It gives the consumer in the state added rights regarding their personal data. Businesses facing various obligations in order to comply with the CCPA Act. Now, you must be wondering what's this cost. Now, I was doing a lot of research as to what is the cost, that all this will be, bared upon. So, a lot of analyst predictions were there. So, I am telling you one of them, that the CCPA will protect personal data worth over $12 billion that is used in advertisement in California each year. Now, that's something to talk about, right? So that's it for today, folks. Thank you so much for joining Tech Talks by Tanya Khanna. If you like my channel, I request you to please subscribe to my channel and share the video if you think that it's going to help somebody. My channel is free of cost knowledge provision for everybody who's out there to learn something new. I hope you really gained something from today's video. Please comment below in case you like the channel and the video. Thank you so much for watching.